5 people died. 3 adults, 2 babies, 1 infant. They perished so young.
A $10 million bond for a teenager accused of murdering members of a Denver family.
It was kind of a shock to us just to think about the idea of bond.
Colorado has long denied murder suspects the right to bond. But under a recent Supreme Court ruling,
some of them are innocent, some of them aren't. And you don't want bonds to be used as a form of punishment.
everyone is entitled to a bond hearing.
Legislation has consequences. This is one of those unintended consequences of legislation.
Tonight, we're going 360 on the court's decision, how that bond is determined,
What really constitutes reasonable when you're talking about the loss of human life.
and the push to let voters decide who's eligible.
Bond was set at $10 million today for one of the 3 people accused of setting a home on fire, killing 3 adults and 2 kids in Denver in 2020. Thanks for joining us tonight. I'm Jessica Porter.
And I'm Shannon Ogden. Gavin Seymour was just 16 years old at the time of his arrest, and today he received what appears to be the largest bond ever set by a Denver County judge.
Denver 7's Rob Harris was in the courtroom and heard from family and friends of the victims.
You might be having the same reaction that the loved ones of victims had, which is disbelief we're even having a conversation about bond when it comes to someone accused of murder.
For us to sit here and talk about bond for 5 victims, a family in a community that's still healing, we heard every day.
Both the judge and the prosecuting attorney addressed this in the bond hearing. They explained that the state Supreme Court ruling earlier this year guarantees bond for all defendants, including those accused of first-degree murder. Still, loved ones feel that this is just another injustice as they wait for closure in this case.
Like, this law is just helping the criminals to do, to do their things. This is not fair. This is not justice. If the guy has money, he can just go and pay and get out while he killed 5 people. That's just like living hell. It's just too much for us.
The judge had to set bond, but she sided with the prosecutor, setting it at $10 million cash only. If Seymour were to come up with the money for his bond, he would also have to surrender his passport and be under maximum supervision. But there's another reason that loved ones feel let down by our justice system, and that's how slowly this case has moved. The Colorado Supreme Court is right now considering whether it was constitutional for police to use reverse Google searches to find the defendants in this case. And some legal experts think this could go to the U.S. Supreme Court. But the judge says she's prepared to move forward as soon as there's a ruling from the Supreme Court.
We're still mourning, and they say time heals, but I know that's a cliche, but it's not healing for us right now.
For Denver 7,
it's still standing still till we get justice.
I'm Rob Harris.
As Rob mentioned, today's hearing came in the wake of a Colorado Supreme Court decision that ruled defendants, even in the most shocking cases, can post bond.
The state Supreme Court made that decision in June. And tonight, Denver 7's Russell Haythorne is taking a 360 look at the ruling and why some local leaders are now pushing for a special legislative session to address it.
Historically, in Colorado, everyone, no matter the crime, has had a right to bail or bond.
With exceptions. And one of those exceptions was if you were charged with a capital offense and proof was evident and presumption great.
A capital offense in Colorado was considered a very serious crime, like first-degree murder with the possibility of the death penalty. But then in 2020, the Colorado State Legislature abolished the death penalty and the bond exception was no longer applicable.
The Supreme Court last month in June of 2023 said because we don't have the death penalty, there are no more capital cases, and as a result, these defendants are eligible for a bond setting.
The Supreme Court was unanimous in this decision, meaning anyone, even those accused of mass murder, can now have a bond hearing.
The court, in my mind, completely correctly said, no, I think this is actually a fairly simple case on the law. That exception does not apply to first-degree murder when the maximum penalty is life without parole. And that's it.
But not all agree.
For someone who's been through a capital punishment trial, to have someone who just committed a heinous crime like that to be on the streets causes a huge public safety issue.
Legislation has consequences. This is one of those unintended consequences of legislation.
Arapahoe County Sheriff Tyler Brown points out Colorado is no stranger to mass mass murder, Columbine, the Aurora Theater shooting, King Soopers, and most recently, Club Q. The sheriff says, God forbid, if future incidents like this were to occur, those accused killers would now be eligible for bond.
If we're releasing people on bail that are facing, the possibility of life in prison without parole, what's to say they're going to come back? And, we're not setting ourselves up for another dangerous encounter. We have to look at this as a community safety issue.
As a victim of the mass shooting here in Aurora.
Aurora Theater shooting survivor Marcus Weaver is against the death penalty, but says it makes no sense to offer bail at any moment to mass murder suspects.
No, absolutely not. It's just really hard to fathom that a judge would allow, someone who's committed mass murder bail. It just makes no sense.
Weaver says it's also about the suspect's own safety.
A mass murderer or someone who's committed, a sexual assault against children and things of that nature, there should not be bond. They need to be off the street because it's, like I said, it's not only protection for them, but also what if they recommit?
Every person is presumed innocent.
But renowned defense attorney Vince Buckmelter argues that's always been the standard. A judge sets bond based on 2 factors.
The 2 factors are flight risk, you want them to come to court, and protecting the safety of the community.
Such was the case last month, testing the Supreme Court's recent decision. David Lechner, an Arapahoe County man accused of gunning down his soon-to-be ex-wife in their garage, had a bond hearing. The judge set his bond at $100 million cash only, meaning he would have to put down the full $100 million to get out.
Generally, if bail is set, you really just have to put down a down payment. 10 to 15% up front.
Associate Professor of Law at DU, Ian Farrell, says that's not the case with cash-only bonds.
With a cash-only bond, you have to put down the whole amount right away in cash. Here it is before you can leave.
Ultimately, there's probably not going to be too many cases where you have defendants charged with first-degree murder who are going to be able to make high monetary cash-only bonds.
But with any amount, depending on the defendant's wealth or access to cash, there is a possibility.
$100 million to a day-to-day person sounds like a lot of money, but we live in the world that $100 million is out there. What really constitutes reasonable when you're talking about the loss of human life?
Which is why Brown believes the governor should call a special session right now to address this and put it to a vote of the people this November.
A special session is going to be needed for a referendum to the November ballot to address the constitutional issue. We need to recognize that these offenses of murder are held without bail.
Farrell disagrees with the sheriff on that.
Personally, I don't think that is necessary, given that the bond can be set so high that there's no way the person's going to get out anyway.
Buckmelter is also at odds with the sheriff.
His opinion is not going to carry any weight because the Supreme Court disagrees. The Supreme Court has said we are going to have bonds set in these cases.
But Weaver agrees with the sheriff and is all for a vote of the people.
Absolutely. I think that is the only way we're going to get a clear-cut consensus.
For now, there is no clear-cut consensus. Just a debate that will likely continue for months, if not years, to come.
Some of them are innocent, some of them aren't. And you don't want bonds to be used as a form of punishment.
This is America, freedom. From that perspective, the starting point is you have a right to bail.
Unfortunately, when these heinous crimes are committed, the victims of these families have to continue to relive this on a regular basis.
For Denver 7,
let the people speak on this.
I'm Russell Haythorne.
And should the bond ballot measure make it onto the ballot next fall, it would need 55% of voter support to pass.